continue with the lecture of Professor Florin E. Elvay.
Thank you and good afternoon. It's always nice to be back here in Silliman. One of my biggest worries when I was Solicitor General was the prospect of having to go around the country explaining how we lost this case. And so I'm very thankful that Justice Francis Hardalesa and I have this wonderful opportunity to go around the country and explain under very happy moments and environment how we actually won the case for the Republic. I am quite aware of the limitations of time and the problem of information overload, delivering lectures of this nature before a crowd whose information about the case can vary from no information to some information to a lot of information. And so Justice Francis Hardalesa and I have decided to divide our lecture, so he focused on the basics of the case, and I decided to focus on the more personal aspect of how we handled this particular litigation. It's an attempt to try to put a face to the case. Everyone who has enough bandwidth to spare or waste can download the decision of the arbitral tribunal and spend 3 to 5 days of his or her life reading that 500-page decision. This is an attempt to try to introduce you to that decision and to the personalities who were involved and the major events that happened during this particular arbitration. I begin with the power structure of the legal team for this arbitration. Those are not the three stooges, they are the legal team of the President. That would be Executive Secretary Paquito Ochoa, a longtime friend of the President, batch 85 of Ateneo Law. In the middle would be Justice Hardalesa, who just lectured before you. He was the initial agent for this particular arbitration. And to his left would be Chief Presidential Legal Counsel at the time, now Associate Justice of the Supreme Court, Ben Tagiwa. Justice Ben Tagiwa was a classmate of the President, I think from elementary up until college. Right, so the President Aquino goes way back with these guys. He knows them and he trusts them at a personal level, which is why they decided to appoint Solicitor General Hardalesa as agent so that they won't be blamed if something goes wrong. So these are the OP guys and the Office of the Solicitor General. The Solicitor General also had another team in the Office of the Solicitor General. The head of that team would be former Assistant Solicitor General Sarah Jane Fernandez, now Sandigan Bayan Justice. Of course, below us would be tons and tons of lawyers who assisted us in reading the materials, processing all the paperwork, looking for evidence. But at the highest level, these are the guys who said yes and no to anything and everything and who were vulnerable to being blamed for any loss. Next slide, please. This is my appointment paper as the agent for the Republic. And so I think that would be March 2, 2015. One of the worst days of my life. Why? Because I positively tried to avoid becoming the agent. I was appointed Solicitor General in an acting capacity in the 21st of August of 2014, the day after Solicitor General Hardilesa became Justice of the Supreme Court, and there was a question of who should replace Solicitor General Hardilesa. I became Solicitor General. There was another question, who should replace the agent? And there were proposals to have Secretary Albert De Rosario as a co-agent. There was another proposal to have Secretary of Justice Laila de Lima as another co-agent. There were proposals for a sub-agent. There were so many proposals on the table, and when I was asked by Executive Secretary Ochoa what I thought about the matter, my answer was, please don't make me the agent. Why? Because I was very busy with my job as Solicitor General. I was a new Solicitor General, and I was scheduled to have my oral arguments in the EDCA, the Enhanced Defense Cooperation Agreement. And I thought that there were enough people who had knowledge of the case who can perform the job of agent for the Republic. But in the end, the decision was that if the case was lost, the persons who will be blamed would be E.S. Ochoa and CPLC Ben Kadiwa, because they left the president to his own devices. And so the decision, the final decision was to make the Solicitor General just like Justice Francis Hardilesa as the agent, so that he can be blamed when something goes wrong. But kidding aside, I saw this as an opportunity to assist the president. I didn't know the president, and I was very thankful for the opportunity to assist him in the most important case that he assigned to me. Next slide, please. What is the role of the agent? The role of the agent is that of a team manager. Usually use the metaphor of a basketball team. You have very good foreign counsel in Paul Reichler and company, Foley Hoag. You have a team of advisors there, your basketball team. And you as a manager, your job is to make the most important decisions and be the bridge between foreign counsel and the president. You're the one who makes the most important policy decisions. You say yes or no to whatever it is that they propose you to sign. And so the most important power of the agent is the power to withhold his signature. And then when I became agent, I knew that I had to clarify the goals of the Republic. Why? Because the interests of foreign counsel are entirely separate from the interests of the Republic. There's an overlap there because both of you would like to win, but you have to realize that every time you hire counsel, counsel will be paid whether or not you win or lose. But on the other hand, the Republic cannot afford to lose big in this particular arbitration. And so we wanted to clarify our goals. On paper, of course, you have our 15 submissions, and that's easy enough to understand. But from a policy standpoint, these are the goals that I set for myself as agent for the Republic. Define the concept of a win. What is a win for the Republic in this case? And you can have different types of wins. You can have an acceptable win. You can have a reasonable loss. You can have an overwhelming victory. There are many different types of win. And what is the kind of win that can make you proud, and that also at a practical level can move you forward in terms of promoting the interests of Filipino fishermen, our Navy, our diplomats, etc. Achieve an efficient win. We recognize the dangers that we expose the Republic to by filing this case. You're up against a neighbor who is also a friend, who also happens to be a military and economic power. There are so many ways by which they can exact revenge because we filed a case against them and they were to that extent humiliated or shamed. You know, in Asian culture, people always talk about the value of the face, the importance of not humiliating your neighbor. And there was some criticism with respect to the decision of the president to just file a case because that wasn't seen as consistent with Asian values of being nice to your neighbor in spite of certain difficulties. And so we wanted to win legally and at the same time minimize the potential cost of any retaliation. We also wanted to reduce the impact of a potential loss. There are so many ways to strategize a case. In the same way that there are so many ways to skin a cat. You can have various strategies for one particular objective, but you must be able to reduce the potential of certain losses simply because at the end of the day, you will have to compute costs and benefits, and you must be able to convince your principal that your calculus was sufficient enough to make his policy decision to file a case the correct choice from a purely instrumental standpoint. And finally, of course, you needed to protect the president. He is your, if the agent is the team manager, the owner of the basketball team will be the president. And as the owner of the basketball team, he has his own stockholders, that would be the entire Filipino nation. He made the political decision to file this case, and you needed to win that case for him so that when he goes back to the Filipino people, he can tell you he made the right choice, and that choice will be his legacy. Next slide, please. Right. This is what Justice Arguellesa was telling you about earlier. There's only one signature that appears in every pleading submitted by the Republic. This was the memorial filed in March of 2014. That's the signature of Justice Francis Arguellesa. Next slide, please. Next slide. Right. So if Justice Arguellesa is dreaming of showing, that particular photo or frame to his grandchildren, you can imagine what are the creative ways I can think of to show this to so many other people. I'm not married, by the way. This is my signature for the supplemental submission that we filed in March of 2015. After the memorial was filed, the tribunal decided to ask us a ton of additional questions, basically expanding the scope of the arbitration. The case that we filed was narrowly written so as, again, to minimize the impact of potential losses, also to ensure that we didn't bite more than we could possibly chew. With the supplemental submission, we were required by the tribunal to look at so many other features that it took us another set of about 2,000 or 3,000 pages of submissions to convince the court that we have a good control over the facts of the case. And so I came in post-memorial but pre-hearing. Pre-hearing on the jurisdiction. Next slide, please. Right. This was, well, now we can tell you our first big disappointment in the case. When the case was filed, we originally had a timeline. And that timeline was about 1.5 to 2 years, ensuring that the case would be decided during the time of President Aquino. Well, not only so that he can explain the decision to the public, but also to have control over the decision, whatever it would be, right? But the tribunal decided to bifurcate the proceedings. What did that mean? It meant that the tribunal wanted to look first at the jurisdictional questions. And if we're able to survive the jurisdictional questions, it was only then that we were allowed to go into the merits phase of the proceedings. This was a bit of a disappointment and a surprise for everyone. Our American counsel, OSG, DFA, and of course, Malacanang. Why? Because we thought that the case was so intertwined, both on the merits and jurisdictional phases or aspects, that there was no way that the tribunal would separate the jurisdictional and the substantive questions of the case. It also brought us an additional worry that the case might actually be thrown out by the tribunal without looking into the merits. When a tribunal tells you we want to bifurcate, we want to look first into the question of jurisdiction, that potentially signals to you that they're seriously looking into the question of whether or not they have jurisdiction in the first place. Whether or not there's a need in the first place to look at the merits of your case. This was also problematic from a timeline standpoint because this decision of the tribunal effectively delayed the case by about 1 year and 3 months, or 1 year and 1.5 years. This decision of the tribunal is the reason why the decision came out after the term of President Aquino. Of course, we wanted to ensure that the case was decided during the term of President Aquino so that there would be some control over the handling of the result of the case. And so this was a big disappointment for us. It affected the way we strategized. It also affected our level of confidence because this was a loss. We saw this as a loss, not a very painful loss, but a loss nonetheless, which made us really concerned about the possibility of surviving this case. Next slide, please. This is a photo of Mischief Reef. Mischief Reef is a low tide elevation within the exclusive economic zone of the Philippines, and this is publicly available. You can download the photo. There's a date to it, and the date is July 22, 2016. This is what is the most recent publicly available photo of Mischief Reef. Next slide, please. These are the closer photos of Mischief Reef. Those are not actual aircraft. I think the guys who did the satellite photography were theorizing about the potential of placing aircraft, the potential for the new features of the reef, and one of the potentials is that you can place an aircraft there. And so prior to the hearing on jurisdiction, there was a question of whether or not we should ask for some kind of a temporary restraining order. In UNCLOS language, it's a request for provisional measures. When we first learned of China's island building activities sometime in 2012, a decision was initially made that we should not ask for provisional measures. But when we learned of the scale, the magnitude, and the pace of the island building activities of China, the entire world community was, correctly alarmed by this development. And it wasn't the burden of the president whether or not to ask for provisional measures. And our final decision was not to ask for provisional measures because we just came from a loss, and it was the understanding of everyone in the policy group that China would not recognize the provisional, any favorable provisional measures anyway issued by the tribunal. And so we didn't want to spook the tribunal by asking them to bet heavily on this particular question. We didn't waive anything because in the end, I think it was a correct decision on the part of Malacanang and the legal team. Because in the end, the tribunal decided that all the land reclamation or island building activities of China harmed the marine environment, and everything that was done within our EEZ had no permission from the Philippines and therefore unlawful to that extent. Next slide, please. This is the entire delegation that we brought to The Hague during the jurisdictional hearing. We were roundly criticized for bringing such a big delegation to The Hague, but we have consistently defended our decision to bring such a large delegation because we wanted to communicate before the tribunal the seriousness of the Republic in pursuing its case. Before this hearing, we visited The Hague just to scope out the place, and we attended one hearing. I think that's a hearing in the ICJ on Peru versus Chile, and the delegation that they brought was much larger. Right? And it was more theatrical because they even brought their native costumes, just to show to everyone how different they were. But these were the delegation is basically composed of members of the cabinet, in particular OP, Executive Secretary's Office, military advisors, policy advisors, and of course OSG. Many of the people here are also from the Department of Foreign Affairs. I asked Justice Francis Herdulesa to join me as special assistant to the agent because he knew more in terms of the genesis of this case and the policy considerations that were made in deciding so many other issues, or so many issues in this case. Next slide, please. These 5 old guys are the ones who decided in our favor. Right? We have to thank them, try to remember their faces. Right? The guy sitting down would be, to your left, would be Thomas Mensah of Ghana. He's the president of the Arbitral Tribunal. The other guy sitting down is Judge Pawla of Poland. The 3 guys standing up, the one in yellow tie would be the French arbitrator, Judge Pierre. In the middle would be our arbitrator. He was the one that we selected, German judge, Judge Wolfram. And, well, the remaining judge is a judge from the Netherlands, Alfred Soens. The decision was unanimous, and so we can thank all of them. Next slide, please. This is the team. I think they got this from Abibaltec. This basically OP, the military, you see SND, and of course Justice Herdulesa, and now Justice of the Sandigan Bayan, Sarah Jane Fernandez. Next slide. This is us during the hearings. Right? I don't often pray, but you can see me there praying. The American would be Paul Reichler, the head of the legal team at Foley Howell, and of course Secretary Albert Del Rosario. You don't see it, but to our right would be a row of empty chairs. That's reserved for China. Next slide, please. I think this is also from the assistant of Secretary Albert Rosario. We were so thankful to be photobombed by the Speaker of the House, Speaker Belmonte, and Abibaltec. Well, the hearing was the first opportunity for us to meet face-to-face the officers and the members of the Arbitral Tribunal. Now, prior to this, we also saw them we only see their photos on the internet. And it's very important for us to see them during the hearings because we wanted to get feedback, how they were responding to the arguments. This case was particularly more difficult for us because we didn't have our opponents on the other side making the arguments. And so we had to make the arguments for them. So we ended up finding the arguments that we constructed would be the strongest possible arguments for China. Next slide, please. I don't know why Secretary De Rosario was smiling, but I was on game face mode there. My back would be Justice Ardilesa looking for Pokemons. No, this was in 2015. Wala pa yata Pokemon Go in 2015. Right? There would be Philippe Sands, the British barrister who argued on marine damage to the marine environment. Another American counsel, Larry Martin, and another British barrister, Professor Boyle. Next slide, please. This is during the hearings, you see there Paul Reichler standing up. I'm asked, how was it making your presentation before the Hague at the ICJ hearing room? And I always say it's really boring. It's so different from what we have in the Supreme Court. In the Supreme Court of the Philippines, it's like the wild, wild west. Right? The justices are, with all due respect, Justice Ardilesa, the justices are always raising their voices at you. They're always out to get you. At The Hague, everything is so civilized and nice. And in the Supreme Court here in the Philippines, you can't say, I'll think about your question, Your Honor. Can I look at my books first and give you an answer later on? You can't do that. It's really, you have to be a gunslinger when you're doing oral arguments in the Philippine Supreme Court. At The Hague, you can nicely delay answering any question by saying, we recognize the importance of your question and the gravity of your question. If you could give us the next day to fully articulate our answers, we will provide you with our considered response tomorrow. And that's a civilized way of saying, I don't know the answer right now, I'll give it to you tomorrow. Next slide, please. Well, the bald guy right there would be me. That is the hearing room of the ICJ. Next slide, please. The important faces here would be the faces of Secretary Albert De Rosario and E.S. Ochoa. They're wondering what I'm trying to say to the arbitrators. The agent makes the opening and the closing statements. The submission introduces the case for the team and makes the final submissions to the arbitrators. Next slide, please. That would be along in the hearings. That will be Paul Reichler, myself, and Secretary Albert De Rosario. Next slide. Again, the President's men, of course, Justice Ardilesa, worrying about his Pokemons. Next slide, please. That would be Paul Reichler. The giant slayer are Michael Jordan. He's the head of the American legal team that Justice Francis Ardilesa hired for this particular case. Next slide, please. Even the laws even the meriendas during or in between the hearings are so civilized. We're always drinking tea. Just to give you a sense of what it was to argue at The Hague, you have 3 sets of arguments in the morning, 1 hour of oral presentations, and then 15-minute coffee or tea break, and then another hour of presentation, another coffee and tea break, another hour of presentation, and then you go to lunch. In the afternoon, you go through the same routine. It's really very boring if you ask me. You also, because this was at The Hague, and we couldn't go there about a month prior to the proceedings, even if we wanted to. Of course, we would have been subjected to COA if we did that. So we had to go to The Hague about 2 or 3 days prior to the hearings. And so everyone was grappling with jet lag while we were doing the hearings. Next slide, please. Right. After the hearing on jurisdiction came the award on jurisdiction. This was a mixed bag for us. On the one hand, it was a win because that meant that the case would proceed to the hearing on the merits, which was what we wanted in the first place. On the other hand, it also made us a bit more concerned about the ability to win this case. Why? Because we had 15 submissions, meaning 15 complaints to be decided by the tribunal. According to the tribunal, in the award of jurisdiction, they had jurisdiction over 7 of the submissions, but they weren't sure yet whether they had jurisdiction over the 7 other submissions, and therefore they would tie that up with the hearing on the merits. And basically, the question with respect to the 7 questions over which they didn't decide on jurisdictional grounds was a question of whether or not there was an overlap, meaning whether Ito Aba or Pagasa Island would generate an EEZ, and therefore if that happened, whether the case would have to be dismissed or those 7 claims would have to be dismissed purely on jurisdictional grounds. And so it was a mixed bag for us. We won the jurisdictional question on the 7 submissions. We didn't think that we lost, but the resolution of the jurisdictional question was to be resolved with the question on the merits in the hearings. Next slide, please. Right. So this is basically the meat of the matter during the hearings. Is this a rock? Is this a rock? And so if you ask, I suppose, a lay person, the overwhelming answer of anyone who doesn't, even someone who's understood and read Juntos, the gut feel answer would be, it's probably not a rock. It's bigger than a rock. This is the question. But for us, the legal question is, what is the legal characterization of this high tide feature? Is this a rock or an island? And so a lot of the debates within the legal team circled around how to handle this particular question. Of course, the result that we wanted was a characterization that this is a rock for purposes of Article 121 of UNCLOS, because it cannot sustain human habitation or economic life of its own. That's a straightforward answer to that particular question. But whether or not you can win it is, of course, another matter. I go back to the President's disappointment with Justice Francis Ardilesa not providing him with a number. Can you give me 90% confidence level? Can you give me 85% confidence level? And Justice Francis Ardilesa refused to provide the President a number. In my case, I knew that was going to be asked, and so I went around that particular issue by saying, well, I can speak to you about levels of confidence, Mr. President. And so during my presentations before the President and E.S. Ochoa and Secretary Ben Kagiwa, I would talk about levels of confidence. And so I have varying levels of confidence with respect to the 3 main aspects of this case. 9-9, I have a very high level of confidence. Why? Because it doesn't seem like 9-9 can really survive scrutiny by these judges. The only way you can survive 9-9 is or the 9-9 can survive is by saying that China can claim historic rights that precede and supersede UNCLOS. Right? And that's crazy. And those arbitrators are, people of integrity, people who are renowned in their field, which is law of the sea. And there's no way they're going to survive making a declaration that the 9-dash line is compatible with the UNCLOS. It's like saying there's no such thing as due process here in the Philippine Constitution, right? But anyway, next slide, please. These are the more specific features of Ito Aba. There's a new harbor, 1195 meters. You have a defensive structure. Ito Aba is the biggest high tide feature in the Spratlys. It's 0.43 square kilometers. It's a shade larger than our own Pag-asa Island. Next slide, please. This is Pag-asa Island, or T2. So it has an airstrip. It's part of a municipality. There's a school there, 200 civilians, anywhere between 200 and 300 military. And so again, the question is this a rock or is this an island? So your gut feel answer might be, well, there's no way this can possibly be a rock. Right? But our challenge was to have the tribunal declare this as a rock for purposes of the UNCLOS. Next slide, please. Right. And again, this is the worry. Given that, going back to my level of confidence, I have the highest level of confidence with respect to the fall of the 9-dash line. I have some level of confidence with respect to the claim that Scarborough Shoal is a set of 6 rocks. You've seen Scarborough Shoal, that's clearly a rock. And then I'd say, I think we have a fighting chance when it comes to the question of whether Ito Aba or Pag-asa is a rock. We have a fighting chance. And so we were really worried, and as Justice Francis Ardilesa told you earlier, it wasn't even part of our complaint at the get-go for the very reason that we didn't want to be the ones who placed that particular issue before the tribunal. Meaning, let the tribunal ask us so that at least we have some deniability for the president in case we lost. So this is the real problem. This would have destabilized, I think, a decision declaring Ito Aba as an island generating 200 EEZ or Pag-asa island generating 200 EEZ would have destabilized the entire South China Sea. Why? Because there's no way you can compel China to a delimitation. It's one of the issues in which they have opted out. And had we lost what would happen the next day would be a press release from China saying that in the case that the Philippines filed itself and in which we did not even participate, we actually won big. And that's the entire point right there. Even with the UNCLOS, they treated the South China Sea as if it were a Chinese lake. What if we had lost? They would have treated it as a Chinese lake with backing from the arbitral tribunal. So that was the real worry. Thankfully, we won that particular issue. Why the tribunal ruled the way it did, you'd have to read that particular portion of the decision. For academics, this would still be the more interesting point of the decision because you'd have scholars who will say that the tribunal veered away from existing jurisprudence. You'd have scholars who will say, no, that is consistent with the existing jurisprudence. For the part of the Philippines, we can only say, thankfully, they ruled in our favor. Okay, that's the northern portion of our claim. You see the small circle right there. That's the territorial sea of Scarborough Shoal. The left blue line to your right would be the extent of our exclusive economic zone. The area in between those blue lines where you have the South China Sea would be the high seas. Next slide, please. This is the southern portion of the claim. You see how messy it is. The effect of the tribunal's decision basically is to contain the territorial disputes to within the white circles. Meaning that because the tribunal is an UNCLOS or an Annex 7 tribunal, it only has jurisdiction to decide maritime claims. It has no jurisdiction to decide territorial disputes. And so who owns Scarborough Shoal? We say we own it. China says it owns it. Then it's a disputed territory. Who owns Pag-asa? Who owns Aba? Everybody disputes that. But who has legal rights over the exclusive economic zone within that peak area that's 200 nautical miles from Palawan? The Philippines. The Philippines alone. That is the win. Next slide, please. That's the entirety of the dispute. The blue line right there is the extent of the blue line in the middle is the extent of our exclusive economic zone. Next slide. I think I'm out of slides. That was the hearing on the merits. The hearing on the merits happened in November of 2015. And the tribunal usually, or tribunals of this nature would decide within a 6-month period. And we communicated to the tribunal the need to expedite the decision to ensure that we don't have to spend any more than is necessary. Politically, we wanted the decision to come out during the term of the president because we had a reasonable confidence that we were going to win the case just to ensure the legacy of the president. But it took a while for the tribunal to decide. It ended up deciding on June 12th. There was a lot of controversy as to when the decision would come out. People were saying it's going to be June 20, it's not going to happen. If it happens after June 30, there's an opportunity to withdraw the case, things like that. But we got an email from the Secretariat of the Permanent Court of Arbitration sometime in June saying that the decision would come out at 5 o'clock of June 12th. And so at 5 o'clock of, July 12th. At 5 o'clock of July 12th, 4:30 actually, I was in the chambers of Justice Hardelesa in the Supreme Court. Justice Ben Tagiwa was also there. We were waiting for the email of the arbitral tribunal from Judith Levine, the head of the Secretariat. And of course, the clock kept ticking, 4:50, 4:51, and at 5 o'clock I kept on refreshing my laptop, and at 5:02 I became really worried because the Europeans are never late. Right? I was worried that something happened, someone missed a train or something, and we got the printout from one of the law clerks. I checked my email, it was at 5:05. The first thing that we did, of course, as practical lawyers, was to look at this dispositive. The dispositive portion of the decision is about 30 pages. And so I kept on mumbling to myself in front of Justice Hardelesa and Justice Ben Tagiwa. Win, 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 win. Except for 3 minor questions, so nothing really to worry about. We claimed that some features were low tide elevation. The tribunal said they are rocks. That's nothing because that's only 12 nautical mile territorial sea. Our 15th submission was declared basically a political submission, and therefore there's no need for the tribunal to rule on that. The standoff at Ayungin was considered as part of a military character, and therefore part of the exemption given to or claimed by China. And of course, as I was wrapping up, Justice Ben Tagiwa asked me, "Did we win on Nito Aba?" And I said, "Yes, we won on Nito Aba," and we all got relieved because of that. And after that, Justice Ben Tagiwa asked me, "What do I tell the president?" And I said, "Just say congratulations. Just say congratulations." And I think he texted something lengthier than just congratulations. About a minute after that, I got a call from the President. Of course, Justice Ardilesa and Justice Bentagiwa were so disappointed na ako yung tinawagan ng Presidente. And when I got the call from the President, I said, the President said, congratulations, Florin. And I said, no sir, congratulations. This is your legacy, this is your call. And then I gave the phone to Justice Ardilesa. We ended up by saying that the President ended by committing to treating us to dinner one of these days, and he needs to fulfill that particular promise so we can talk about this particular case. And that, my friends, is the story of how we won this. Thank you and good afternoon.
We thank Professor Defai for his lecture. At this point, I would like to call on the Dean of the College of Law, Dean Sheila Lynn Catacutan Empresario, as moderator for the open forum.
Good afternoon. This is now your chance to ask questions to our two distinguished lecturers. If there's anything that's bothering you on the West Philippine Sea arbitration, this is your time to ask. Can you please state your name and then address your question either to Justice Ardilesa or Attorney Zilman?
Good afternoon, Dean Sheila. Good afternoon, sir. I am a student from College of Law, Student University. I have two questions. First is, now that we have the award and China is quite stubborn in adhering to the award, is it a potent action, sir, to put an economic sanction through ASEAN partners to China so that it would somehow adhere to the award or to the ruling? And my second question is, what are the courses of action our current government is planning to do now that we have the tribunal's award? That's all. Thank you.
Thank you. Well, because I am no longer Solicitor General and agent, and Justice Ardilesa is now with the Supreme Court, no longer an agent, we can give you a very short and definitive answer. We can't definitely say what should be done. We don't want to put ourselves in a position of telling the new administration what to do. We always say the game of the lawyers is done, or basically done. This is now the game of the diplomats. The game of the generals, that's a game that we don't want to play. We want to make that game as minimum as possible. I don't think anyone can envy the task that is ahead for the current administration. Whether economic sanctions are even feasible, whether we can corral our neighbors to convince them to use economic sanctions against China. It's a matter that is quite beyond my expertise as a lawyer. That's for the trade guys and the diplomats to consider. But what I can tell you is, despite the quote-unquote stubbornness of China, I think the world recognizes that this is a binding decision. Binding decision, and the award itself is already final. There's no motion for reconsideration. There's no appeal. This will stick. This will stick, and this will stick for quite some time until some reckoning is had, until some enforcement is made. What we've been able to accomplish basically is the declaration and recognition of the full extent of our rights under the UNCLOS. So the goal now is to find some correspondence between what we were able to have declared and the facts on the ground. Again, I don't think I have any positive recommendations to the administration. I'd let them play this game. Thank you.
Thank you, sir.
Do you have other questions, please?
Sir, good evening. you mentioned that the decision to file a case was a difficult decision for the president. So can you please tell us on a personal note what made the president decide to file the case?
You know, when I gave the phone to Justice Ordoñeza, you know what he said to the president? Mr. President, congratulations, but please write your memoirs as soon as possible so you can tell us the considerations that led you into filing or deciding to file this case. I think the president and the policymakers, the legal team, they've been thinking about this case, or, well, in Filipino, kinakasa na talaga yung case. But it wasn't until the president decided to say, go ahead and file, you know, that we actually decided to file. What made him decide, I think it's, well, maybe Siliman should invite him. Now that he's citizen, Noynoy Aquino again, that's probably one of the questions you might want to ask him.
Let me give some details to that. I understand my predecessor as Solgen Cadiz. As the first meeting with the president was October 2011. Remember the standoff in Scarborough was April 2012. So, as early as October 2011, after the Reed Bank confrontations, Solgen Cadiz had a meeting with the president, and the president said, study. You will remember in the first two State of the Nation addresses of the president, meaning in 11 and 12, he already hinted about recourse to international remedies. I came in February 2012 as Soldier. Almost immediately, I was asked to continue the studies. By May 2012, I had my first meeting with Justice Feliciano. By the next month, we were shuttling back and forth to Washington, D.C. So that's 2012. Towards December of 2012, the American lawyers have come to the Philippines, have gone to the Navy, got the pictures. We had drafts. By January 11, 2013, on January 11, the team made a final trip to Washington, D.C. January 17, the team, under Secretary Ochoa, gave a final memo to the President. These are your options. The team unanimously recommends, if you want to, we can file a case. We had a draft, so that's January 17. 17, after that, your question, I don't know. That's why I asked the President, sooner or later, sir, I would like to know, because in one of his exit interviews on TV, he said this was the most difficult decision that he had to make. That's why they say, the presidency is such a lonely job. Because at the end of the day, you may have all the advisors, you may have all the experts, but you make the call. So 17, we gave him the final memo, saying all hands on deck, unanimous. If you want to, we can file. January 22, we were called, prepare, it could be tomorrow. So we had the petition finalized. Overnight, we had to put everything in order. Everybody was on standby. So January 23, early in the morning, Cabinet meeting, immediately after that, National Security Council. This is full cabinet plus the Speaker, the Senate President, the members of the minority, and the former presidents. It was a go on January 29. I will remember that because I had no sleep. January 23, when we filed, was the day the cybercrime law was going to be argued in the court. So I stayed overnight. Half of my time was doing my arguments. Half of the time was refreshing my notes because we might be asked in the National Security Council. So that is what happened. I don't know what pushed the president, but this is really a big decision on the part of the president, and we should recognize, and I keep saying, mabuti na lang nanalo tayo. Because had we lost, you can imagine what kind of legacy the president would have had.
Good afternoon, sir. I am a fourth-year law student. My question is, what do you think China is going to do? Are they going to leave? Are they going to continue building? Or are they just going to blow themselves up like we wish them to do?
I really wouldn't want to give them any ideas as to what to do. I'm sure the environment, within the policy departments in China is very noisy right now. They're considering all their options. And Justice Francis Hernandez always says it's a closed society. There's really not a lot of access as to information about what they intend to do. So there's really no way for me to tell you, what they will do. As a Filipino, I can tell you what I think they should do. That is to follow the decision, because they rely on international law for so many other matters, and for them to be considered as a good neighbor, as a power that ought to be respected and recognized, they need to comply with the rules of the game. It's not as if they weren't part of UNCLOS. They are a state party to the UNCLOS, and the UNCLOS has a compulsory arbitration or settlement dispute mechanism, and they are bound by that. So notwithstanding that they did not participate, they are bound by the decision or the final award of the tribunal. So I hope that they will comply.
Thank you, sir.
Thank you. I'd like to give the microphone to the gentleman in red who wanted to ask a question earlier. And then for those who also want to ask subsequent questions, just if you could pose yourselves with the microphones that we have in the auditorium.
Sir, good afternoon, sir. I would like to ask her, there is a possibility that China won't adhere to the decision of UNCLOS, sir. Do you think that the United Nations can do something in order for China to follow the ruling of the UNCLOS?
Yeah. I recognize that everyone's looking for ways to enforce the decision. And I think at some point, we'll have some clarity as to how to move forward with respect to this. Answering your question, I'm not a UN person. I don't know what they are considering at the moment. There's so many pieces of that puzzle, for you to have an enforcement of that particular decision. And you need to have an environment that is really feasible to make it an imperative for China to comply. How those puzzles will come together, I really don't know. That's not my expertise.
Thank you, sir.
Good afternoon, sir. I'm from the College of Business Administration. I have seen in the news that China has refused to acknowledge the case and also our victory in the arbitration. So what do you think is the significance of our victory since they refuse to acknowledge it? Then what does that mean to them? What significance will it make for us to be able to reclaim our rights without them trying to disrupt it?
Well, the current rhetorical environment in China, and I emphasize the word current, is that they are not bound by the decision and that they will not recognize the decision. But that is their current statement. Insofar as the rest of the world is concerned, they recognize the binding nature of that decision. And that will bind China for a very long time, so long as we hold on to the line and say, we stand by this decision, this is a legitimate decision. I think people will have to recognize that the enforcement of the decision will take some time. Whether it's going to happen tomorrow, 5 years from now, or beyond our lifetime, we do not know. But that is a fact of international law, that these things will take some time. But if you're looking at the intrinsic value of the win, the intrinsic value of the win is that we now have the advantage. Why? Because clearly the law has been declared to be on our side. And so we have now reclaimed our rights. We have been able to validate our claims through an impartial tribunal. And when people ask, what is the law on this particular matter? And we say, well, this is the law on this particular matter and the law is on our side. That's not us using just propaganda or making propaganda. That's us echoing the decision of an impartial tribunal. And so when you talk to a Chinese scholar, for example, or someone who's on China's side on this particular question, and he tells you this and that, China wants this and that. Well, what you can say is, yan ang sabi mo. But when we read that 500-page decision, which is a decision issued by a tribunal with jurisdiction, in a case that was decided and under a compulsory dispute mechanism in which China is a party, then we have to go by that particular ruling.
Thank you, sir.
My name is Grace Sarduan Burgos. I'm from the PhD of Nursing program. My question is, I'm just curious, since we have won the case, is there a possibility that other countries who also present as claimants can contest the decision of the tribunal? And secondly, does the Hague or the International Tribunal have come across the same similar situation as we are facing or that we have faced?
Well, this case is the first decision on the disputes with respect to the South China Sea. Right? In relation to your first question, I don't think it's in the interest of the claimant, the other littoral states or the claimant states to contest that decision. In fact, it's the other way around. They will use that decision against China because while the decision is binding only between the Philippines and China, the reason, the rules, and the principles that were articulated in that decision apply to their dispute with China as well. Which is why I think at some point we have to claim something against our neighbors because we're the ones who fought this out against China, and the entire time they were simply behind us. They would tell us we're behind you, but just behind you. Right? It's time for them to step up. Actually, I hope they could foot the bill to some extent, but they will be benefited by this decision because this decision essentially clarifies the rules of the game with respect to the entire China, or most of the South China Sea.
Except that they cannot topple down any more the infrastructures that have damaged the surrounding and the environment. So probably the Philippines would end up negotiating with China on what better way to utilize, because I think it's more damaging again to remove an infrastructure that has been put in. First of all, they should have not done it, but it did happen.
Well, I'm not an engineer, and so I wouldn't be able to tell you whether it's worse for China to remove all those artificial islands that they built. Thank you.
Good afternoon, sir. We're here. Before I state my question, I would like to thank you, honorable sirs, for your effort. Now, Attorney Hilbay, you mentioned rather you mentioned about the game of the diplomats, and we all know that our current president isn't exactly the typical diplomat out there. And so, without making this question sound ad hominem, what, in your opinion, how confident are you that we can expect to see the fruits of your labor effected or put into play during the current administration?
The future is still very uncertain at this point. As you said, you have a president who has a unique way of responding to stimuli. And who knows, that just might be what is necessary for us to be able to get the result that we want. I think you have to be fair to President Duterte. He's only been there for, 67 days or 70 days. It's too early in the game, I think, to make any solid assessments of the pluses and minuses of the strategy that they have adopted. In fact, we don't even know whether they have already come up with a concrete strategy. At this point, everything is really fluid, and I would suppose that their assessment on a daily and weekly basis is also changing. And as rational people, they would also have to adjust to the changing environment.
Thank you.
Good afternoon, everyone. Good afternoon, Mr. Dubai. My name is Benno from the Department of Foreign Affairs. No, sorry, from College of Foreign Affairs here at Philippine University. Hopefully, I'll be part of the DFA soon, sir, because that's exactly what I'm looking for. Anyway, I have three things that I'd like to ask. First is that I am a foreign affairs student, so I am somehow quite more informed of the gravity of the dispute that we have between China. But I just want to know, and I just want you to educate everyone of the possible, or what could have been the worst case scenario if we lost this particular dispute with China. And secondly, I would also like to know your opinion about the matter of how can we make China abide the decisions of the tribunal without sacrificing much of our diplomatic ties with China. And thirdly, since this is about the 4 island constructions that has been built in some features in this Bradley's and in some features in West Philippine Sea, or should we call it, South China Sea, I don't know. But I want to know, how do you think can the government utilize these structures, or what do you think is the government planning to do on this structure since it's already there? Maybe withdraw it or destroy the place?
The tribunal declared that those structures were built without our authorization. The tribunal did not declare that those structures are ours now. Those are two separate things. According to the tribunal, the artificial island building resulted in a near permanent damage to the marine environment, and so that's a separate obligation of China under both UNCLOS and another convention. But the tribunal did not declare that the Philippines can now take over those structures because it now is the true owner of those structures. The structures built on Mischief Reef, Mischief Reef is a low tide elevation, and so it's a feature that is not subject to appropriation. It is simply that because it is within our EEZ, exclusive rights over the reef or the low tide elevation lies where the Philippines has the relevant coastal state. That'll be my answer. What was your first question?
First question, sir, is what could have been the worst case scenario if we lost the dispute?
There are many, I'd say, bad case scenarios. One bad case scenario would have been a dismissal of the entire case on jurisdictional grounds, in which case we get sufficiently embarrassed by China. They're going to lecture us. Another bad case would be one of the features, the highlight features in the Spratlys being declared as an island, and therefore would generate a 200 EEZ, which means China would practically appropriate the 200 EEZ to its exclusive use. Another really bad case situation would be had the tribunal declared that historic rights can exist prior to and after the UNCLOS, in which case the South China Sea would be converted practically into one big Chinese lake. And Vietnam would definitely have complained. Malaysia, Indonesia, the Philippines definitely would have complained. And who knows what would have been the net result of that kind of a situation.
Thank you. We are now on our last two questions. So let's have a question from up here and then the last question.
Hello, I am Ella, a grade 10 student from junior high. The bilateral talks that our administration is planning, would they be effective in the end? And would they yield good results?
I commend you for your political sensitivity at this very young age. I was hoping you'd join Justice Ardelesa and search for Pokemons. No one knows really what's going to happen in these bilateral talks. The nicest way you can put it is by saying that this is a move forward. At least now we're talking. And when we get to talk with China, you have this 500-page document that you can carry with you and say, anytime China says something that is against our interest, oh wait, I think we might have to refer to page 150 of this decision first. I think China doesn't want that, but how we respond to China would really be best left to the president. And his calculation of a win and when that win ought to be achieved. You know, one of the disadvantages of a presidential form of government is that you only have a 6-year timeline for a stable policy. Every time you have a new president, there's the potential for a change in mindset, negotiating attitude. That's one concern. And so it's really very difficult to think long-term in terms of foreign policy when you talk about this particular issue, which might be generational or intergenerational in scope.
Thank you.
Thank you.
Good afternoon, sir. My name is Milka from the College of Law, and my question is, since you have mentioned a while ago that the case is unappealable, right? And since China did not participate on the case, is there a possibility for, say, for China to bring a legal ground for them to appeal some aspects of the case, since I haven't also read the full text? Who have?
Both in the decision on jurisdiction and in the decision on the merits, the arbitral tribunal spent an inordinate amount of time talking about the effect of China's non-participation. And the tribunal has been quite emphatic on the consequence of that non-participation. It has no effect whatsoever. Why? Because the Annex 7 contemplates that particular possibility of a state party not participating in an arbitration of this type. And the answer there is the absence of the party is not a ground to excuse itself from the consequences of the final award. Because the tribunal considered itself as having jurisdiction and considered itself as having been validly constituted. There's no ground, therefore, for China to complain about its absence as an excuse to question the award.
Thank you, sir. Thank you very much. As much as we want to continue with the open forum, but we also have some time constraints. But if you still have questions for Attorney Hilbay or Justice Hardileza, you may write them on a piece of paper and then we'll gladly give it to them and put in your email ad, because I think Attorney Hilbay would reply to you through email. So that ends our open forum, and we'd like to thank everybody who asked their questions.
The campus beside the sea is deeply grateful to our lecturers, the Honorable Justice Francis H. Hardileza and Professor Florin T. Hilbay. And to present the certificates of appreciation, I would like to call on stage Dr. Ben Malay III, Attorney Miles Nicolas Bihar, and Dean Sheila Lynn Katakutan Bisario. Let me read the citation. Silliman University presents this Certificate of Appreciation to Honorable Francis H. Hardileza, Associate Justice, Supreme Court of the Philippines, for enriching the academic and intellectual life of the university as speaker in the General Education Integrative Learning Lecture Series on How the Sea Was Won, the West Philippine Sea Arbitration, given the second day of September 2016 at the Claire Isabel MacGill Luz Auditorium, Silliman University, Dumaguete City. Signed, Ben S. Malay III, President. The same citation goes to Professor Florin T. Hilbay, Professor, College of Law, University of the Philippines, Diliman. At this point, I would like to call in again Dean Sheila Lynn Katakutan Bisario to close this afternoon's lectures.
Thank you, Jello. I think everybody is in agreement that we are awed with the efforts of these two individuals here on stage, a giant in our Philippine litigation as they headed the case against China in the West Philippine Sea dispute. So I think the Filipino people owes you a great thank you. And can we give them a round of applause? So indeed, our children and grandchildren will be talking about this case because this is a very important part of our government. So in behalf of the College of Law of Silliman University, of course, the integrative lecture series of the university, and to all the Silliman University community, we'd like to thank Justice Hardileza and Attorney Hilbay for coming to Dumaguete City and giving their precious time to us and for telling us about the West Philippine Sea dispute arbitration. And on a final note, it's very nice to give faces to the cases that we read. As law students and as lawyers, we read them and we look at them as letters and we memorize them, but it's very important that now we see faces and we hear the side stories. So we thank them for the opportunity that we now have this afternoon. And to all of us, to all of you, thank you for coming. Thank you for enriching the academic life of this university. Good afternoon.
The struggle is a part of the Filipino DNA. We struggle for independence, we struggle for social justice, and now we struggle to maintain our seas. And with that, I invite everyone to please rise for the singing of the Silliman song.